Hello, everyone. Good evening. My name is Advocate Ajinkya Udane. I will be giving this small webinar on law of writs. Basically, what comes to your mind whenever we talk about writ petitions? Usually, I, being an advocate, when I was in my fourth and fifth year, I used to get very confused that whether I can go and file my matters, if I have any, directly in the High Court, or whether I can file any matters in the Supreme Court directly. But then I decided to do internships, and after doing internships, I understood one thing, that it's not that easy that any person can directly go and file his matters, or any aggrieved party can directly go and file their matters in any high court or any supreme court, because there are specific stages of litigation, like such as district court, high court, supreme court, or sometimes a tribunal, and then high court, and then supreme court. So writs will come under Constitution of India, which is the Bible for lawyers and for the law students. And whoever is an aggrieved party, he has to follow the Constitution of India. In the Constitution of India, it has been clearly formulated that under what sections and under what articles you can file your petitions. For example, under 226 and 227, you can knock the doors of the Honorable High Court. Under Article 32, which is the original jurisdiction, you can knock doors of the Supreme Court. Now we will start. What exactly comes to your mind when we say writs? Writs, can it be a command or can it be an order, or whether a writ is an order or whether an order is a writ? This is also a very important thing. Writs were introduced in India way back during 1861. That time, Supreme Court of India was situated in Kolkata, and now it is in Delhi. In 1950, when the Constitution of India was formed, the Supreme Court of India was shifted from Kolkata to Delhi. And below that are the high courts, which are situated in all the states, as well as few high courts have been given the charge of various union territories, such as the Honorable Bombay High Court has been given a charge of Goa, which is a union territory, as well as Daman and Diu. Therefore, whichever matters in relation to constitution law or under Article 226 and 227 will have to be filed in Bombay High Court. That jurisdiction has been, or the Goa bench of the Bombay High Court. Bombay High Court has 4 benches. One is in Aurangabad, Nagpur, Mumbai, the principal bench, and Goa. So now we will start with writs. The first writ I want to explain, before going to the writ, I'll explain the constitutional remedies. There are 2 constitutional remedies. First is Article 226. Second is Article 32. Now I'll read out the Article 226 directly from the Bare Act so that it will be easier for us. Power of High Courts to issue certain writs. Notwithstanding anything in Article 32, every High Court shall have powers throughout the territories in relation to which it exercises jurisdiction. The writs should be in nature of Habeas Corpus, Mandamus, Prohibition, Quo Warranto, or Certiorari. Now I'll take you straight away to Article 32. You don't have to refer to any articles. I'm just going to read one line so that it will be easier in your mind and you'll understand what exactly can be filed where. Now I'll be taking everyone to Article 32. So Article 32 will straight away tell us remedies for enforcement of rights conferred by this part. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part, which can be guaranteed. Now under Article 32, if there is any fundamental right which is being breached, then an aggrieved party or an advocate or a party in person can straight away file a matter under Article 32, and he can file a writ petition in Supreme Court. But if you tell me that if the point of the matter is not in relation to fundamental rights, then can I straight away go to Supreme Court? Then the answer is no, because the Supreme Court may direct you that there is an alternative remedy, or there is a remedy which is available in law under Article 226. So first you avail that remedy and then come to Supreme Court. So under Article 32, under very limited aspects, that is, if any fundamental right is breached, or if you are not able to get your fundamental rights, or if you want, or your fundamental rights have been infringed, then only on that limited scope you can file a writ petition in Supreme Court. For example, I'll tell you right now, everyone is aware of what is going in Maharashtra because of the political scenario. Why didn't the political parties in Maharashtra straight away go to Bombay High Court, and why did they directly go to Supreme Court? Why? Because of the fundamental rights of each and every citizen or of each and every member has been breached. Therefore, petitions were filed by way of special leave petitions were filed directly under Article 32 as well as under the rules of Supreme Court directly in Supreme Court. They didn't come to High Court, or else it would have been difficult for them to go to High Court and then Supreme Court because of the efflux of time, because they had super limited time. And that was the only reason why Supreme Court entertained these petitions. Now, coming back to the point, now I'll take everyone to Article 226, under which High Court has been given the power to issue writs. Now I'll straight away take everyone to difference between writ jurisdiction. We have already discussed the difference between the writ jurisdiction of Bombay High Court or of any High Court and the Supreme Court. Now we will talk about the types of writs. The first writ, which is very, very important, writ of habeas corpus. Writ of habeas corpus, what comes to our mind whenever we say habeas corpus? Habeas corpus, if you ask a layman is not going to understand this term. But if you ask any legal professional or a law practicing advocate, he will understand what is a habeas corpus. And these days, the scope of habeas corpus is very, very narrow, because what is happening that instead of availing the remedies which have been given in law, people are availing the remedies through writ of habeas corpus. For example, Nawab Malik, who was the minister of Maharashtra, he had filed a writ of habeas corpus stating that his custody with PMLA as well as ED is illegal in law. Therefore, that writ of habeas corpus was rightly rejected, and interim relief was rejected by the Honorable Bombay High Court, stating that PMLA has taken you into custody and has taken you into legal custody. You cannot say that it is an illegal custody. I'll explain it in a simpler way. And habeas corpus means you may have the body. The use of the habeas corpus is if anyone himself or any of the family members or friends are in a wrongful custody, then a writ of habeas corpus can be filed. For example, if the cops come and just arrest someone without any reason or without giving any 41A notice, or if they have taken up any person into custody by wrongful contentions or has kidnapped, then a person aggrieved himself or through his family members or through his friends, relatives, advocates can directly go to High Court and file a writ of habeas corpus under 226. The High Court has an inherent power to direct the government to produce that person, whoever is in the illegal or wrongful custody. These days, what is happening whenever there is a dispute between a husband and a wife in custody matters, in custody about their kids, wives or the husbands either are straight away filing the writs of habeas corpus stating that the kid is in the wrongful custody. High Court and Supreme Court time to time has heavily come upon both the parties, stating that writ of habeas corpus is not to gain the rightful custody of the kids, or in these kind of matters. It has to be used very sparingly, because the scope of writ of habeas corpus is very, very limited. Habeas corpus may be applied by any person who is not a stranger. So if any aggrieved person is today, if Nawab Malik is in wrongful custody, I, being a random person to Nawab Malik, or I being a stranger to Nawab Malik, I cannot file a petition under 226 stating that Nawab Malik is under wrongful custody. Therefore, habeas corpus has to be filed by a person who is related to the aggrieved person. The second writ we will be studying now is the writ of Mandamus. The writ of Mandamus is one of the very, very widely used writs. What comes to our mind whenever we say Mandamus? Mandamus means command. Whenever a High Court can command any governmental authority or any government body, or under Article 12, whatever is coming under the definition of state, High Court has a wide power to give commands as well as directions to get the work done legally or through some machinery which is related to the government under Article 12. Now, writs cannot be issued to any independent person as such. No XYZ person can file a writ petition in any High Court stating that direct advocate Ajinkya Udane to take my matter. I, being a private party, a writ cannot be issued against me. But if I am a government employee and it is my job to get that work done, then anyone can go under Article 226, file a writ, getting a direction against me. I have to complete my duty towards the government just because I am a government authority. So in these cases, a writ of mandamus can be used. I'll give you some more examples in writ of mandamus. If I file an application before the Tahsildar for land acquisition or before the collector for land acquisition, if the land acquisition officer or the collector has kept my application pending, I can file a simple writ petition under 226 seeking a writ of mandamus, a direction to the collector or to the Tahsildar or to the land acquisition officer that kindly hear me or kindly pass any orders or kindly act in accordance with law. This is the scope of writ of mandamus, seeking a direction to any governmental authority. Now I'll give a small example. I am dealing right now, I won't name the client, but I'm dealing right now in a defamation complaint which has been filed by one of my clients. We have filed a writ petition in the High Court seeking a direction against the Information of Technology IT department of the government of Maharashtra. As well as we have made a private party of YouTube, Google, LinkedIn, and we have made a private party to Facebook also. Now, when the matter was listed for the first time, the advocates appearing for YouTube raised a preliminary objection that Advocate Ajinkya Udane cannot seek a writ against me. He will have to seek a writ against the Information Technology Department, and they can pass us orders. So this objection raised by the advocate for the respondent was being allowed by the court, and the court told me not to seek any writ against these private parties because these are private individuals. And the court has asked the Information Technology Department to file a reply. This is the example why I wanted to give. That means to just to make you understand that a writ of mandamus cannot be sought against any private party. Now we have completed 2 writs. Now we will go straight away to a third writ of prohibition. As the name suggests, the writ of prohibition is a court petition issued either by any Supreme Court or High Court. A writ of prohibition is an extraordinary writ of preventive nature. Prohibition, whenever we say prohibition, what comes to your mind is prevention. It's better to prevent something before any wrongdoing is taking place or before anything happens. Then only writ of prohibition can come in the picture. Usually, a writ of prohibition comes in the picture. It is like more of a prerequisite or pre-legal process, not a post-legal process. So therefore, if anyone is apprehending that something like this may happen, then a writ of prohibition can be filed for. A writ of prohibition has wide powers, but comes with a very limited scope. For example, grounds for issuing a writ of prohibition are very, very specific. First is absence or excess of jurisdiction. If any government authority or if anyone or if any government body, statutory body is acting in excess of its jurisdiction, if your fundamental rights are violated, if natural justice is not followed, if there is infringement of fundamental rights, or if there is error of law on apparent of the face of record, then only you can file for writ of prohibition. Writ of prohibition also has to be filed either in the High Court or in the Supreme Court, but that's what I said. Again, Supreme Court may tell you that you can avail your remedy under 226 in the High Court instead of directly coming to the Supreme Court. So in that way, writ of prohibition prohibition matters can be filed. Now, going ahead, we will go ahead to writ of certiorari. Writ of certiorari, a lot of people get confused between writ of certiorari and writ of prohibition. There is a small peak line between these two things. I'll first explain the writ of certiorari and then I'll explain what is the difference between writ of certiorari and writ of prohibition. Writ of certiorari, I'll read it out. This writ is corrective in nature, which means the purpose of this writ is to correct an error which is apparent on the records. So the error already has taken place. Here, error is not going to take place, which we are apprehending. Error has taken place. This can be issued when the superior court wants to decide a matter in the case itself, or if there is an excess of jurisdiction by an inferior court. This can be issued. This writ can also be issued when there is a fundamental error in the procedure followed by the inferior court, or if there is a violation of the principles of natural justice. Now, there is for filing a writ of certiorari, the body or the person, whoever is filing, should have legal authority. Any random person or any layman cannot just go and file a writ of certiorari. Such authority should be related to determining those questions which affect the rights of the people. Such body or person has to act judicially in implementing its functions. Such a person or body has acted if acted in excess of the jurisdiction or legal authority. When all these conditions are fulfilled, then only a writ of certiorari can be issued against the body or persons who has acted in excess of the jurisdiction. Now I'll tell you the distinction between a certiorari and prohibition. Usually, a person gets confused in the start that if my fundamental rights are infringed, or if at all there is something wrong which has happened at the face of record, what should I do? Whether I should go and file a matter under writ of certiorari, or whether I should go and file a writ of prohibition. Now, writ of prohibition is a writ which we can seek when we are apprehending something, that something wrong may happen or the wrong process is followed. But a writ of certiorari can be filed when something wrong has been done. Now it needs to be corrected. So it comes at a later stage. If the problem which we are facing, or the aggrieved party, whatever problem they are facing, if it has crossed the stage, or the final orders have been passed, or the subordinate court has acted in excess of its jurisdiction, or has passed orders which are not as per the provisions of law, then that person will have to file a writ of certiorari in the High Court or in the Supreme Court. So this is the peak difference, like a small line between these two things. We will now proceed to writ of Quo Warranto. The writ of Quo Warranto is easy to understand. Why? A writ of Quo Warranto can be filed to seek a challenge to someone's appointment, or if someone is holding any wrongful position in any government authority, or if someone is misusing the power which has been conferred by the Constitution or by its own law, which are stated as per the provisions law. For example, I'll give you, if at all there is Mumbai University Chancellor, the rules framed by the state government are, for a Mumbai University Chancellor, PhD qualification is required for the person who is seeking for that appointment of being a Chancellor of the Mumbai University. If the Mumbai University Chancellor is not holding the PhD qualification and still he is appointed, then we can always seek, by way of filing a writ under writ of Quo Warranto, we can always move the court and tell that as per the rules or as per the provisions, the minimum qualification is being given PhD. Then on what basis this person's appointment has been done? In these kind of cases, writ of Quo Warranto can be passed by the High Courts. Now, by passing these orders by the High Courts, it's not that easy that any person goes and files a writ petition. But for filing a writ petition, you need solid and concrete proofs, first of all. Second, your locus, whether you are a genuine person, or whether you have been sponsored, or whether you are being politically motivated, or whether you are doing this for some other wrongful gains. This is seen. Third thing, every writ petition, whenever you file any writ petition, you will have to give your supporting documents for that. Fourth thing, you will have to, all the writ petitions have to be filed by way of an affidavit. Without filing an affidavit, it will be, your writ petition may not be maintainable, and this will be the first preliminary objection which will be taken by the respondent, that there is no affidavit on record. So on what basis is this writ being filed? These are the things which everyone will have to follow while filing a writ of any writ of Quo Warranto, writ of Habeas Corpus, or certiorari. Now we will go straight away to Article 32, that are writs of Supreme Court. Now, writs of Supreme Court. What comes to your mind whenever we say that I am filing a writ in the Supreme Court? Is it that easy for everyone just to go directly to the Supreme Court and file the writ? No. Over there, like I had stated earlier, that if at all any constitutional right has been infringed, or something which has gone like haywire, like something which cannot be reversed, then only you can knock the doors of the Supreme Court under Article 32. And because there is always a remedy which is available with us under Article 226. Usually in most of the High Courts, I won't say all High Courts, because every High Court has its own rules. Like how Bombay High Court has its rules, Bombay High Court appellate side rules, Bombay High Court original side rules. So most of the High Courts have their own rules. Usually all the writs under Article 226 will go before a division bench of any high court. Or if at all a new bench has been formulated, it may be of 3 judges, 5 judges. Usually the number of judges is odd. So that if 2 people are saying yes, 2 people are saying no, then the 5th person can decide whether it's a yes or a no, so that the ratio can be maintained. Usually all the writs go before the high court, before a division bench. And if it's a writ of certiorari, like something which has to be challenged or an order of an inferior court, then that can be filed before a single judge of the Bombay High Court under Article 227. The first and the foremost goal, I'll tell everyone, is for effective working of these principles and goals in real life is to prevent the misuse of these rights and liberties. Judiciary has particularly constituted the constitution by giving these specific powers to High Court as well as Supreme Court. Usually what happens if a layman comes to you, and if you're an advocate or if you're learning law, if a layman comes to you and discusses his problems, it's not that easy for us that we will have to go to the High Court. We will have to go as per the stages of the court, that is the District Court, High Court, and then Supreme Court. So in this way, I can explain the types of writs.
How can writs be used for Lok Adalat judgments?
Usually what happens that under 226, the constitution has given the high courts an inherent power. Usually a Lok Adalat is being headed by a retired high court judge. But there is a small misconception in people that Lok Adalat awards or the settlements which have been done in front of the Lok Adalat cannot be challenged. So this is a wrong misconception, or this is a wrong thing which people are following, because any order can be filed or any order can be challenged before a high court under Article 226. It is totally on high court to decide the legality and correctness of the order. It is not on us to decide whether we can challenge it or no. So even a Lok Adalat order or a settlement which has been done before a Lok Adalat can be challenged before a high court by way of a writ petition under Article 226. We will have to see what exactly are the facts, and accordingly we can select whether what prayer are we going to ask for. Whenever we file a writ petition, we have to support it with the grounds of objection. Recently, the Chief Justice of our Honorable Bombay High Court, while he was sitting and dealing with a writ petition, has specifically stated that all the writ petitions which are not being followed by grounds of objections, if you have not specified under what ground you want to object or what grounds you are giving for setting aside the order, then those petitions will be dismissed. Usually what was happening, people were writing the facts, people were annexing the documents, but there were no grounds given. Under what ground are you challenging today, or under what ground are you aggrieved? So your writ petition should have the facts of the petition, the documents which you are relying on, the grounds of objection, concluding paras, and the main part of your writ petition is going to be the prayers. What exactly are you asking the court? What exactly do you want from your writ petition? So this is the way in which this is the way I answer your question.
What is the filing procedure of writs and PIL, that is public interest litigation?
Okay, the filing procedure for writs and PILs is totally different. Writ petitions can be filed under 2 categories, as well as PILs can also be filed under 2 categories. Writ petitions can be filed under civil, it may be a civil writ petition, or it may be a criminal writ petition. If you are seeking for a quashing of a FIR, it will be FIR is of a criminal nature. So that will come in a criminal writ petition. If you are seeking for a quashing of an order which has been passed by an inferior court, which is a civil court, then you will have to file a civil writ petition. But for a PIL, it may be a criminal public interest litigation. If the party is seeking prayers which are of criminal nature, then it may be a criminal PIL, criminal public interest litigation, or it may be a civil public interest litigation. A public interest litigation will have to be filed with a separate affidavit, as well as with the details of the petitioner, as well as you'll have to be very specific about the locus of the petitioner. Because what is happening these days, people are filing PILs out of political motivation, or they are being sponsored by someone, or they don't have proper grounds to file PIL, but still they are being filed on a day-to-day basis. Only to curb down this practice, now what rules, appellate side rules say that, or the original side rules say, whenever you're filing a PIL, you will have to support your PIL by way of an affidavit, a separate affidavit of the petitioner. So this is the difference. Whenever we file a civil writ petition, you don't have to give a separate affidavit. Your affidavit can be a part of your civil writ petition. But whenever you file a PIL, it has to be supported by way of a separate affidavit. So this is the way PIL can be filed. And in writ petitions, your writ petitions can be under Article 226 and 227. So they may go before a division bench or a single bench. Over here, your PILs will go always before a division bench or a bench which is for more than 2 judges.
If SEBI has not passed the order and pending investigation has prohibited someone from accessing securities market, then can the writ jurisdiction be availed, especially when there is no order passed by SEBI?
Yes, a writ jurisdiction can be availed. For the same example which I give you about the Tahsildar, that I have made a simple application before the Tahsildar that kindly allot me the land which you have taken for under the garb of reservation, kindly allot me that land back. Tahsildar has not passed any order, but still I go to High Court seeking a direction that at least pass some orders. In the same example, I'll fit SEBI. If I am before SEBI, I have made an application, and if SEBI authorities are not passing any orders, then I always have to go before the superior court to take a simple direction that at least hear me, at least pass some orders. So in this way, yes, I can seek a writ of mandamus against the SEBI authorities, or in any, the same thing, the way DRT also works. Right now, when DRT was not sitting during the COVID times, the number of the DRT tribunals, most of the DRT tribunals were not functioning because of COVID. Then that charge was being given to Bombay High Court. So a writ petition had to be filed, seeking a direction to the DRT to hear the matter. So usually what happens, not only SEBI, any other authority, the highest court is Supreme Court, below that is High Court, and below that is rest all the courts. So if you want to seek any direction against but if you're seeking any directions against judicial officers, then the procedure of filing the civil writ petition is totally different. You will have to make that judicial officer a party in person, and you'll have to give 2 copies of that on the government leader, as well as you'll have to make up Registrar General the party. Then only you can file any matter against the judicial officer, or else your writ petition may not be maintainable.
How RTI Act will affect the general conditions of using the writs?
Filing an RTI is nowhere near affecting a writ. So you file an RTI, you don't get the answer, you go to the appellate authority of the RTI. The appellate authority of the RTI is also not giving you any answer, or even if they are not hearing you, then by way of a writ petition, you can seek a mandamus against them. But I'll give you an example. Day before yesterday, Delhi High Court has stated someone has sought for RTI under the PM Cares Fund. So the PM Cares Fund, the Delhi High Court has straight away stated that PM Cares Fund is not a government body. So we cannot direct them. So if you are filing any RTI application in a government body or any statutory body which has been formed by the government, or it is under a government, or it is a corporation under Article 12 of the state, then only you can seek an RTI information. If it's a private body, or if it's of a private nature, or if it's an independent body, then you cannot seek an RTI application, or you cannot seek a mandamus seeking a direction to the RTI authorities to provide me the information. So this was the same thing. This issue was involved in the PM Cares Fund. People were making RTI applications to the government seeking how much funds have the PM Cares Fund collected till now, where all it has been spent. All the high courts have taken the same view, that the PM Cares Fund is not coming under the government authority. It is an independent mission under Prime Minister's Yojana. Therefore, we cannot seek any direction to the PM Cares Fund that you kindly give all the details. And so you'll have to see from which authority you are seeking an RTI for. If it's coming under Article 12 of the state, or if it is a government or a statutory body, yes, then you can seek a mandamus. But if it's not coming, then you cannot.
So RTI, if I'm not able to get the information from a particular authority, then I'll be able to go through the writ of mandamus. You wanted to say that?
Yes, ma'am. But it depends which authority you're talking about. If it's a private authority, then no. If it's a government authority, then you will have to make an RTI application. If your RTI application is not answered within the stipulated time, then there is an appellate authority of the RTI application. If even the appellate authority of the RTI application is not hearing you or not passing any orders, then only after availing all the remedies, then only you can come to High Court directly and file a writ of mandamus. Not before that. because high courts and supreme courts have specifically stated that if you have an available remedy in law, or if there is an alternative remedy, then you have to use all your remedies, and then only you can go to high court or the supreme court. Because if I am the advocate for the respondent appearing on behalf of the government, that will be my first defense, that my learned friend has filed this writ petition without availing the remedies which have been given to her in law. She has straight away come to high court by filing these petitions. She should be directed, the petitioner itself should be directed to avail her remedies or to exhaust her remedies which are available in law.
If I filed PIL or writ petition, which is totally issue based and it is very urgent to be heard, so can we mention urgency before court, or there is any urgency application? And if there is any urgency application, then how to approach the court with that?
Okay, that's a very good question. So I'll tell you the basic process in which your civil writ petition or your PIL may be heard. The moment you file the PIL or the moment you file the civil writ petition, I'll give you two examples. I'll give you an example of Delhi High Court and I'll give you one example of Bombay High Court, because both the High Courts has its own rules. Because every High Court has been conferred under the Constitution to have its own rules to set up their own functioning, the way they want to function. So in Bombay High Court, whenever you file a writ or whenever you file a PIL, after filing the writ or the PIL, you get a stamp number or a registered number. The earliest number which you get is a stamp number. And after removing of office objections, you get a regular number. The moment you get the stamp number, you can go before that court which is holding the sitting of, or which is holding the power to hear PILs or writs. You can go before that court and you can mention the matter by stating the urgency in the matter. If the court thinks, yes, there is an urgency in the matter, the court will circulate your matter. The court may keep it on the same day, court may hear you tomorrow, or court may say, I'll keep it after 2 weeks. You kindly send a notice to the other side. Whereas if the same thing is filed in Delhi, or there are a few more high courts, it depends from court to court totally, because they have their independent powers, so they have made their independent rules. In Delhi today, if I file any matter, after 4 working days, that matter will get listed for sure. I don't have to mention anything. But yes, if my matter cannot wait for 4 days, it is of that urgency, then I can go to the Chief Justice or I can go to that court and mention that matter for an early hearing or early listing. And the second question which you had asked, can an application for urgent hearing be made? Yes, an application for urgent hearing may be made or can be made, but it's not a compulsion if you are mentioning the matter. But you can always put that urgency in a separate application, which is called as an interim application. Everyone knows Code of Civil Procedure. Whenever we say interim injunction, that for the time being at least. So we can always make an interim application and we can put the urgency in that application, and we can try circulating that interim application, that you hear my PL and civil writ petition at a later stage, but kindly hear me for my interim reliefs right now by way of an interim application. So this is the way you can mention your matters and get those matters listed.
What is the time limit to file a civil writ petition after receiving an order from district court?
This totally depends on the articles which have been provided under the Limitation Act. Usually that time starts the moment you seek an order. You can make an application for the certified copy. Totally depends on what kind of an application or what kind of an order you are challenging, whether you are filing a civil writ petition, whether you are filing a civil appeal, second appeal, first appeal, or a civil division application. The time frames for everything is different. For writ petition, there is no such time limit, but the conduct of the party is seen. Usually people follow 30 days to 60 days, or sometimes people follow 30 days to 90 days. But if at all you are challenging any order which has been passed in 2018 and 2019, then the court may heavily come upon the conduct of the client. That just because what were you doing for these 2-3 years, or are you able to explain the delay which has incurred, or are you able to explain the delay so that the court can condone? So what you can do, if there is a delay, if an order has been passed by an inferior court, and if I want to challenge that order, and there was a medical emergency at my place, I'm a client today, I go to my advocate after 120 days, I tell there was a medical emergency at my house, I was not able to come to you before that, then your writ petition can be followed by way of an interim application for condonation or delay, or else you can take it as a ground in your writ petition why there was this delay in filing this matter. So conduct of the client or the conduct of the party is seen while condoning the delay. if I am your respondent advocate, and if there is substantial delay, and if you have not actually taken a ground why there was delay, then I, as a respondent advocate, can always object, stating that when and whenever the petitioner feels he cannot just come to the court, there is substantial delay, my lord may not entertain this petition. So there is no limitation as such.
If a revision application is pending at the district court, can a person file a writ petition in the High Court?
What are you seeking? But if you are seeking the same reliefs which are in the revision application, then it's a no. But if you are seeking that your revision application is pending for a long time and then there are no steps being taken, then yes, you can file a writ petition seeking mandamus to the subordinate court to hear the matter in a time-bound way. But you cannot ask for the same reliefs which you have asked in the revision before the High Court if the revision application is pending. Thank you. Thank you all.